Odinga and Uhuru Kenyatta's names will be in the ballot for these fresh elections. Joining me in studio now is Muthomi Thiankolo, who is a lawyer. Always a pleasure to have you here. Thank you very much for coming in. Fresh elections. Should it be between Raila Odinga and Uhuru Kenyatta or all the other 8 candidates?
Akisa, there are many answers to this question, and unfortunately they don't point in the same direction. There are 2 general places you can look for these answers.
Yes.
Number 1, in the Constitution itself, which is to say Articles 138, Articles 139 and 140. And number 2, the second place to look for the answer to this question is in election petition number 5 of 2013. That is the Supreme Court decision of 2013. Now, the controversy, in my view, arises because of 2 broad reasons, again, tied to the things I said. Number 1, our Constitution uses the term fresh election in different contexts and with different outcomes. For instance, if you check our Article 138, it talks of a fresh election in the context of when none of the candidates has met 50 plus 1 and 25% of the votes cast in at least half of the counties. So that is one context in which this term is used in the Constitution, and this is the only context the Constitution itself specifies who can run in the ensuing fresh election. And it says in that case, it is only the top candidate and the runners-up candidate who can run in the fresh election. Now, this term is also used in Article 139 and Article 140, which are different contexts altogether.
Yeah.
In Article 139, it presumes, or rather it addresses the context where a person who is elected president, that is a president-elect, dies before assuming office. And again, the Constitution says, in that case, then the running mate shall be sworn in as an acting president, and a fresh election shall be held within 60 days. It is important to note that in this context, the Constitution is silent on who can run in the fresh election and who cannot run. Maybe I should have said in the earlier case when no candidate has met the threshold, the fresh election is to be held within 30 days, which is distinguishable from these other fresh elections. This term is used again in Article 140, which is the one relevant to our situation. Article 140, sub-article 3, when an election of a president-elect is invalidated by the Supreme Court. And again, the Constitution says a fresh election shall be held within 60 days. It is important to note here that the Constitution does not specify who can and who cannot.
So there's some levels of ambiguity on the law with regard to who can run and who can't run in fresh elections.
Yes, I was about to finish wrapping up this. There is another strange term which is not relevant here, also used in our Constitution, which is new election, as opposed to a fresh election, which is the situation where no candidate is validly nominated, and then the IBC is to countermand the Gazette notice and repeat the process again. Again, the Constitution is silent on who can run in that new election. So the problem at the first level is that there is a way our Constitution itself is a bit convoluted on these terms and who can run and who cannot run. Now, having said that, this matter was actually litigated in the Supreme Court in 2013, and it is one of the issues that were framed in the decision, and in particular paragraphs 289 to paragraph 294 of that decision. The problem yet again is that even that decision is not very useful on who can and cannot run in the fresh election. If you read paragraph 289, for instance, it tells you that all the 8 candidates in the invalidated election could actually run in the fresh election. Yet when you go to paragraph 291 of the same decision, it says if the petitioner was the runners-up in the invalidated election and he was the only candidate who had filed an election petition, then the fresh election would only entail him and the candidate who was the president-elect. In this case, it would mean, since Raila Odinga was the only candidate who challenged the election, and he was also the runners-up in the results that were published, then going by paragraph 291 of that decision, he would be the only other candidate other than the president-elect. But the matter doesn't end there. There are other paragraphs which address this problem. If you go to paragraph 293, it talks of a situation where two or more of the candidates would have filed an election petition. Of course, this does not apply because we know that of the candidates who ran, only Raila Odinga filed a petition. But
yes. Mudhomi, sorry to cut you short. With all these snippets of the law, bits and this here and there, saying that, where does that leave us now with the current situation we are in?
There are two answers to what is the best way forward.
Yes.
One is to treat the 2013 decision as that which lawyers call obiter dicta, which means remarks made in passing, because these issues were introduced in the case by the amicus curiae. So this particular issue was not actually one of the complaints that were taken to the court in 2013, and therefore any opinion on it must be seen as remarks in passing, and therefore not an expression of the law. And if we take that view, then the result would be, since the Constitution itself is silent on who can run and who cannot run, then the best scenario is to allow all the 8 candidates who had participated to run in that fresh election. The other way is to look at the matter that, fine, this matter may have been introduced by the amicus curiae, but all the parties in 2013 had the opportunity to comment and to make submissions on that particular question, and therefore that opinion of the Supreme Court in 2013 is still the correct expression of the law, which would mean only the top 2 candidates would run.
Let's go to the date that has been set there by the IEBC that currently seems to be dividing the political class. NASA has already rejected that particular date. Jubilee is in support of that date that was given out by the IEBC. Essentially, what should go into, what should IEBC consider before they set a date? What is in the law?
The truth is, as long as the date is within the span of 60 days envisioned by the Constitution and the decision of the court, legally speaking, the IEBC could fix any date. I would rather imagine, and I hope IEBC learns from past controversies, that there is no value in invoking legal fiat if some of the players in the process are not comfortable with the date. So that if I were to offer advice to all parties involved, maybe they should get on a round table and agree which is the most. We've already had enough controversies and problems about this presidential election. Taking a hard position just for the law's sake, in my view, is not going to take us very far.
Ekuro Okot says that he will be filing a petition in the afternoon for being locked out and even trying to sue Wafula Chebukati over that particular decision. What are the likely scenarios if indeed he files this petition?
Now, one of the issues I'm interested to learn is his petition here will be filed in the High Court. And
he said he's going back to the Supreme Court.
Oh, then in that case, then the Supreme Court may have to tidy up. It can give a new clarification altogether or affirm the position taken in 2013. The only problem with the 2013 decision is that it is not very helpful because it has conflicting scenarios, some of which would allow Ekuru to run and some of which would not allow him, yet you would have expected the answer lies one way or the other.
There's been the question of the irregularities and illegalities that were committed during this particular election. And those are some of the issues that NASA is raising, that we can't go to another election when the Supreme Court really rubber-stamped our concerns that there were irregularities. We need some people out. Just clear the air for us as far as those working at the IEBC being ousted before we conduct a fresh election.
There are are two answers. Again, one legal, the other one political.
Political, of course.
My professional qualifications are only in law, so the political aspect I can only point out, but I can't give you an answer. And the political question is, if you have been condemned by the highest court in the land for engaging in illegalities and irregularities that nullified such an important election, then where is your moral authority to preside over the ensuing election? So for me, that's a moral political question, and I must say I have no answer to it.
We'll be speaking to politicians later. They were giving us
the legal question, the answer to it is simple. Number one, the Supreme Court itself directed that it is the IBC that must conduct the election. And if I read the order, they did not say it is IBC as reconstituted. There is also legal precedent. We have invalidated elections countless times before, and the repeat election has always been done by the same IBC, same officers, so that as a strictly legal question, for me, no issue arises because the IBC can still conduct the repeat election. As to the political and moral aspects of the problem, it is beyond my professional competence, therefore I cannot comment on it.
If the IBC sticks to its guns, that 17th October will be the date for fresh elections, is there space for anyone to go to court disputing this? And what would be the process?
For you to go to court complaining about the date, you would have to show that there is something illegal the IBC has done in fixing that particular date, or alternatively, you would have to show that holding the election on that particular date will strip the election of the minimum constitutional requirements, which we've described here before. It has to be fair, to be transparent, to be accountable, to be verifiable. So you'd have to link the date with a breach of any of those minimum requirements. Otherwise, for me, your case will be dead on arrival.
Which court would this be taken to?
Usually the prevailing legal position is that all disputes relating to a presidential election or any stage of it are to be filed before the Supreme Court. That's the prevailing general view. Okay.
Mudomi, thank you very much for coming to just clear the air on some of the things and on what really the law says. Mudomi Thiankolu, a lawyer, just explain.